In this video I want to go over the relationship between the Employment Standards Act in Ontario and the payments due on termination of employment as contrasted with the wrongful dismissal claim. Let's deal with the Employment Standards Act first. So the statute is designed as a minimum standards statute. It sets out minimum payments or notice that must be provided on termination of employment. It has basically two requirements depending on length of service. If the employee has more than 3 months of service, then he or she is entitled to 1 week, and then after 2 years, 2 weeks, etc. until 8 weeks, where it caps at 8 weeks notice. That's called the termination payment or notice obligation. In addition, there's a second obligation that's called severance pay, which is based on years of service once the employee is over 5 years of service and the employer payroll is over 2.5 million. In that case, let's take the extreme example that caps at 26 weeks. So let's take the extreme example of someone with 26 years of service with a payroll over 2.5 million. That person on termination of employment is entitled to receive 34 weeks pay without the need to sign a release. And also, benefits must be covered for the first 8-week period, known as the termination or notice obligation. That can be a formidable obligation. So even if the employee finds new employment on day 1 following termination, that payment is due and owing. The second component of the claim is based on a wrongful dismissal claim, which is based on fair notice. The statutory payment comes off that claim, and also the employee has an obligation for the common law claim to mitigate or look for other employment. That obligation arises after the expiry of the statutory period. So in the example I gave of 34 weeks pay, the obligation to mitigate arises upon the expiry of that 34-week period, and if the employee then finds other employment during that time to the end of the notice period, that income comes off the claim. That's called the duty to mitigate. Now, it's more complicated than what I've described. The statutory payment can have other significance apart from what I've described, as we'll discuss when we consider employment contracts. If a contract violates the employment standards obligation, then the contract will be tossed and the severance provision using the contract will not be enforceable. Let's go back to the notice obligation. So under the termination or notice obligation for the first 8 weeks, all benefits must be covered for that time period. It does not apply to the severance payment section. So if somebody is terminated, not only are they entitled to vacation credits and any other benefit of employment for that 8-week period, they're also entitled to the insurance coverages. Now, disability insurance is particularly complicated because when you're terminated, you cannot buy alternative disability insurance. So let's suppose someone on the day of termination suffers a heart attack. The claim is not for 8 weeks lost disability. The claim is for all the disability benefits that person would have been entitled to for the full extent of the period of disability. So if that person can't work for the rest of their lives, then there's a claim that can be made for all lost disability insurance benefits until the expiry of that time period of disability or age 65, which is always a cap, whichever comes first. So it can be a formidable issue. Employees should always get medical advice before they consider signing a release. Once you sign a release, you give up all such claims. So it's very important to be careful, get legal advice. I'm not a lawyer, get legal advice. The common law claim also can give rise to such a claim. So let's suppose someone suffers a heart attack, not in the first 8 weeks, or whatever the period of notice may be, but in the common law period. In that situation, the employer can be sued for lost disability benefits, again, to the extent of the disability. In the first section I mentioned is the insurance company that's still on the hook and or the employer to be safe. So it's not just simply the obligation to continue these benefits that's important. The claim that can arise can be formidable. So it's important to understand how these two things integrate together. Also, on termination of employment under the statute, again, all vacation pay is due, salary to the date of termination, and basically any entitlement that you are owed by the employment relationship until the date of termination, and all benefits for the statutory notice period, and again, the value of all benefits for the common law period. Is that too complicated? That can't be. Thank you.